Okay, we will go ahead and get started. Thank you everyone for joining us this morning. My name is Kristen Stratton, and I am a parent consultant with NorCal Deaf and Hard of Hearing Services. And it is my privilege today to introduce you to Jeff Nickerson, who will be our guest speaker. Jeff is a very experienced attorney, and his area of law that he practices is estate planning. And he also is a parent of 2 adult children with special needs. And he's going to be speaking to us today about wills, trusts, special needs planning for our children who are deaf plus. And so without further delay, Jeff, thank you so much for your time, and please take it away.
Well, good morning. Thank you so much for inviting me. I am passionate about sharing information about special needs, so it's a pleasure to talk to you. One of the things about living here in California, the state of California has better benefits than anywhere else in the country. The problem is it's complicated. And so hopefully I'm going to try and clarify how we plan for our special needs family members and kind of walk you through some of the various benefit programs that are available out there. Next slide, please. I'm not going to go through the details of my background. I do want to say that I do have 2 adult children, one with cerebral palsy and one autism. And so not only do I have the education and legal knowledge, but I've lived it myself. I've been through the schools and the special education programs. I've been through applying for the various benefit programs and so forth. So I have lived what I'm going to talk about, and I enjoy speaking. I speak into a variety of groups that I really enjoy. Next slide, please. We always have to put this as a disclaimer that the following presentation is legal information and not legal advice. And I like to explain why we say that. All attorneys say that, but whenever we're talking to individuals, we're gathering a lot of information, and key facts can make a big difference on how we advise people. And so therefore, when talking to a group, we're talking in general terms. So please don't run off and take specific actions based on it. But I think overall knowledge about what's out there and so forth is so important. Next slide, please. So why plan? Why plan for your deaf plus family members? Really, there's 2 reasons. There's to maximize and coordinate the government benefits. Like I said, there's a slew of government benefits. Recently I did a presentation to the Riverside County Bar, and I came up with 11 different various government benefits that are out there. And I find a lot of our families aren't taking advantage of all of them. The second and very important reason is to set up a life plan for your family member. So what happens as you age? What happens when you pass on? You want to set up a plan, a lifetime plan for that, for your family member. And that's what I'm going to talk about. Next slide, please. So agenda, we're going to try and cover a lot of things today. I'm going to first talk about special needs planning. What's a trust, what types of special needs planning, what not to do, some of the drafting, funding, some of these aspects of special needs planning. And then we're going to cross over to benefits. And I'm going to kind of rush. There's a lot of benefits out there, like I just mentioned. I'm going to kind of rush through those quickly, but just go and give you a overview of what things are out there that I think you'll find can really help your family and your individual. Then we'll talk about, if we have time, I'll hit across some other services. I really enjoy questions during this. So if you have any questions, please, you can address it via chat, you can raise your hand and so forth. Kristen is going to be monitoring that for questions, and will be interrupting me for questions. There may be times I may say, we'll hold off until the end or whatever, because I know it's coming up, but please ask questions. If you have a question, others probably have the same question that you have. Let's move on. Next chart, please. So what's the best way to protect our deaf plus family members is a special needs trust. It's something you've got to do sometime. It allows for you to leave money to your family member, knowing that those funds you put into that trust will to protect them from protect their benefits, and also will go solely to for their benefit for their lifetime. Next slide, please. So what in the world is a trust? It's a confusing concept, and I'm going to try and clarify it as best I can. So think of a trust as a bucket, okay? Your bucket, you're going to put your stuff in that bucket. You're going to put maybe a house in that bucket, maybe funds or whatever into that bucket. A trust is actually a separate legal entity. It's kind of like a corporation, but it's not a corporation, it's a trust. Trusts have been around for hundreds of years. And there's always three roles in every trust that's ever done. There can be three different roles, but the same people. So the first role is that of a trust maker. The trust maker, and that's probably you listening to us right now, the trust maker creates the trust, makes the trust. That's the most powerful position of the three roles. Also called settlor, grantor. I like the term trust maker because you know what it is. The second role is trustees, and you will probably be also initially the trustee. The trustee manages the assets in the trust, puts money into the trust, distributes money, makes decisions on the money, and you're also going to be the trustee of your trust. And then you're going to name successor trustees, people to step in after you if for some reason you can't serve, old age, pass away. And then finally, beneficiaries. For a family trust, typically the beneficiaries are going to be the people who create the trust. For a special needs trust, the beneficiary is always going to be the individual that is creating the trust. Typically what we do when we're creating trust is we're going to create a family trust. It's going to be a revocable trust. And then we're going to create a separate special needs trust. And so funds generally will flow from that family trust into that special needs trust. Today, we're going to focus primarily on the special needs trust aspect of it. Next slide, please. There are special needs trusts can be placed in three major categories. First party trust. When we say first or third, first party trusts mean that it's the individual, it's the beneficiary's own money, and that's usually by an accident inheritance. I'll talk about that in a moment. Secondly, there's pooled trusts. These are run by nonprofit organizations. And the third type is a third-party trust. We say third party because that's not the disabled person's own money. It's somebody else's money. This is the most common type of trust, and certainly the best type of trust. And I'll get into that here in a moment. But first, let's talk about a little bit more about first-party trust on the next slide, please. So a first-party trust, again, I emphasize this because it is so important. It's the disabled person's own money. And usually that happens by an inheritance that comes directly to a person. If that inheritance goes to a special needs trust, that's usually bad because it might impact their benefits. It can also be things they don't have control of. It could be a personal injury suit. Frequently we'll see proceeds from a lawsuit based on a birth incident where the beneficiary has some disabilities due to a birth incident. They get money that may require a first party trust. We can also see a work injury. We see that less often in the special needs world, but that certainly happens. Or just gifts. The key thing about a first party trust is it maintains those so important benefits, those Medi-Cal benefits, those SSI benefits, all the other benefits I'm going to talk about. Hugely important. The big drawback with a first party trust is that when that individual passes away, Medi-Cal will come in and recover all the expenses that were paid out during that person's lifetime, which is usually going to be all of the assets that are remaining. So it's not a vehicle to leave assets to a next generation because Medi-Cal will take those assets. There's certainly some ongoing advocacy to change that rule, but right now that rule stays in place. There's some various rules about who and how a first party trust can be set up, under age 65, parent, grandparent, and then the actual beneficiary can set that up. Again, usually we're only dealing with special needs trust because there was some bad planning and somebody received money that is on benefits that wasn't expected. Next slide, please. We'll talk about pooled trust.
We'll be switching interpreters.
So what is a pooled trust? If funds are limited, a pooled trust might be the answer in setting up a trust, avoiding the expense of setting up and managing either a first or third party trust. Pooled trust they're nonprofit organizations that gather funds from many people. Each amount is separately accounted for, and they issue checks. The advantage about a pooled trust is any funds, like a first party and a third party trust, any funds in that trust don't count for the government benefits. That's the advantage. Generally, if there's funds remaining, the nonprofit will often keep the remaining funds. I have a problem with that. And it's basically what a check writing service. I am not a big fan of pooled trust for our special needs family members. Generally, they need more care and so forth. Pooled trust can be a good thing for certain individuals, certain situations, but generally, I have been unhappy with pooled trust. And again, are generally not appropriate for those with special needs, need special care and so forth. Next slide, please. So let's talk about a third party special needs trust. I want to emphasize it's not the disabled person's money. So that's the key difference. The key advantage is there's no payback with a third party trust. So what it is, it's generally the parent's money, somebody else's money going into that trust, and the trust maker is usually the parents. The trustees are typically the parents and follow-on trustees, and the beneficiary must be the disabled individual. A key thing, like the other time, it maintains those important benefits that are so important. And of course, we have to name people to manage those assets. And that's probably one of the biggest challenges is who do you name as a successor trustee? One of the nice things that is included in a third-party special needs trust, unlike a pooled trust, is the ability to dictate personal care and goals and advocacy. A separate person that can advocate on behalf. When we're talking about what money can come into a trust, it's generally there's some rules that are more driven by the benefits. But I often get asked, what is the rule on spending money outside of a trust? What is the rule? It's actually a very simple rule. It's called the sole benefit rule. So long as those funds are being spent for the sole benefit of the beneficiary, it's going to be a proper expenditure. Maybe some minor exception, but if you follow the sole benefit rule, you're gonna be in good shape. Next slide, please. The third-party trust is the best legal structure to protect family members. I like the third-party trust. There's no payback period, so you can use it as a savings device, funding device for your special needs individual. I've said this a couple times. I'm going to repeat it because it's a concept that people don't understand. The funds can only be used for the beneficiary, but it's not the beneficiary's money. Let me give you an example where that becomes very important. Is usually if you're a beneficiary individual, you'll get a call or a letter from Social Security or Medi-Cal. One of the questions they'll ask us, does your son or daughter have a trust? And people are thinking, oh yes, we created the special needs trust, so yes, he has a trust. That's the wrong answer. Your son does not have a trust. It's not his money. It's your trust, your money, but your son is the sole beneficiary. So I stress that over and over. Oftentimes when people say yes, then they get this panic call. They'll get a comment, oh, we've overpaid you. You're going to have to pay money back and so forth. And people come into my office in a big panic. And I generally say, well, you answered the question incorrectly, but don't worry. Just send a copy of the trust in and the issue will go away. And it always does. Let's move on to the next slide because I want to talk about what things you should not do. So obviously, you should not be leaving money outright to your individual person who's receiving benefits. They're going to lose the SSI and Medi-Cal. I think the majority of people know about it, but I still run across that every once in a while. Another one I see every once in a while, hopefully people don't do this, but they'll disinherit their child with a disability. That is just, I don't know how people can do that, but that used to be, attorneys in the old days used to actually recommend that. Clearly, you don't want to be disinheriting your own child. You can leave the funds in a special needs trust. What I do still hear frequently is people say, oh, and I hear this like weekly, people will say, I'm going to leave my assets to the sibling, the child's sister or brother, and they're going to take care of those funds on behalf of my disabled son or daughter. Wrong, 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 wrong. The problem is once the sister or brother receives their money, it's their money. Now they could be evil and just use the money for their own good and ignore it. Hopefully that doesn't happen. But those funds can be subject to creditors. What does that mean? So let's say that they had an at-fault auto accident and forgot to pay their auto insurance bill. And now those creditors, the people they hit, can come after those funds that were intended for the disabled individual. The other problem I see is those funds would be commingled with community assets. So instead of kept in a separate account, it's commingled with community assets. A divorce occurs. The one spouse gets half the assets, and that certainly wasn't the plan. And then, of course, the person can pass away, and the funds are going to go someplace else unless planned. So these are some important things just not to do. Let's move on to the next slide. So in drafting a special needs trust, it has to be drafted with some very specific language to meet the rules that have been set up by Social Security and Medi-Cal. Clearly, one of the biggest thing is the beneficiary can never be a trustee. The beneficiary can never have the right to revoke the trust, assign benefits, has zero control of it. And there's what I would call lots of magic words and phrases. We quote various statutes that are in this document to ensure that it's compliant with the various government regulations. We are big advocates of a standalone special needs trust. So, like I said earlier, we have a family trust and typically a separate special needs trust. Oftentimes, people will create the special needs language within the family trust. And I advocate against that for two reasons. One of them is that you've got a document that was created by the parents for the parents, and statistically, the parents are going to pass away years, decades prior to the disabled individual. So then you're trying to manage the finances of the disabled individual through the parents' trust who are long gone. The other important reason, which maybe is more important, with a standalone trust, people can leave money to family members. And so I see this a lot where grandparents will leave, $50,000. And I see this frequently. They'll leave $50,000 directly to the individual. The thought by the grandparents is wonderful. So it's so nice that grandparents are thinking about benefiting the individual. But if the money is left directly to the individual, they're going to lose their benefits. And now we're running around trying to make sure those benefits are either spent down, put into a first party trust, whatever. If you have a standalone third party trust, parents can leave money, anybody, a neighbor or grandparents, usually grandparents, can leave money directly to the special needs trust. They know that those funds must go for the benefit of that. Once those funds are in the special needs trust, Redditors, anybody else can't do that. It's a special needs trust is a rock solid document that creditors or other people can't access. If funds are being used out of a special needs trust, not for the beneficiary, there's a criminal act going on. Somebody's stealing money. Another important aspect is I enjoy with standalone special needs trust, what we call a memorandum of intent. Here, parents can include specific language for the benefit of the individual. Unfortunately, a lot of our families, their only child is the special needs, and then it's important to leave funds directly to that trust. Do we have any questions at this point?
Hi, Jeff. Yes, we have a question. So I know selecting a beneficiary is a very important part of the process on developing the special needs trust. So in certain situations, some families are unique in that they may not have a family member that they can necessarily designate to be a either co-trustee or successor trustee. What typically happens in those situations where there's either a single family home or a single parent with just the one child with a disability and really no extended family? What do you typically do in those situations where there's a very limited number of options for successor trustees?
What a perfect question that I'm going to address on the next slide. So let's move on to the next slide. So selecting a special needs successor trustee, I think that's what she mentioned, beneficiary, but I think she meant successor trustee. And this is probably the most difficult thing to do, and also the most important, selecting that successor trustee. And so frequently we'll see family members, but that may not be the best choice. Being a trustee requires managing funds, maintaining benefits, a whole slew of things I'm going to get into in a moment. But do they have the skills and so forth to manage those assets? And then what happens if you've got a very high functioning beneficiary? You can imagine the issues that arise when one sibling is managing the assets of another sibling. Sometimes there can be issues that you can well imagine. But what happens if you don't have anybody? I think the example from the question is, what if there are no other children and so forth? I am a huge advocate of California professional fiduciaries, and I always bring that up in every conversation. And if we're not naming a professional fiduciary as the first or second, maybe as a third backup. So what is a California professional fiduciary? Well, fiduciary is actually a verb, meaning that you always put somebody assets in head of your own interest. So you have a fiduciary relationship. You're required to have that other person's interest above yours. But it's also a noun in the sense that there's fiduciaries all over the country. Here in California, to be a fiduciary, you have to take a whole series of classes. You have to take a test. You have to be bondable, meaning be able to get a bond and so forth. And if you're going to take on a special needs client, you need to have those special skills in managing a special needs trust. So I think that's the primary answer is if you don't have anybody else, name a professional fiduciary. I know I work with several here in our local area, and it's really the best way to go. The only negative is they cost money, but certainly they cost money. You hear about these trusts. There are several like large banks and financial institutions that act as a trustee. And so professional fiduciaries are going to charge much less than that. But I think that answers the question. Also, what you're doing is you can also name an advocate. And so maybe you have somebody that's very close to your family member, has known him for years and so forth, and just has advocated, taken care of, provided care and so forth, but has zero knowledge about it, handling money. So you might want to name them as an advocate. The trustee is required to listen and consider their advice, but then to be, especially if a professional fiduciary, they're going to be managing those funds in an appropriate manner. The goal of any trustee of a trust is to balance the quality of life and manage those so those funds can last a lifetime. And so it's a trade-off that must be managed. So next slide, please. So trust administration, what are the responsibilities of a trustee? I want to say on one hand it's complicated, but on the other hand it's not all that complicated. It's just prudent investment. The invest managing the assets, typically those should be in a managed fund. So there's enough funds there. Excuse me. And distributes funds. There's a requirement to distribute funds. I've had situations where people have not distributed funds, and they're supposed to be distributing funds, keeping that quality of life. Maintaining accounting. So annual accountings have to be done. This is not all that complicated. It's kind of like a checkbook register. What money went out, keeping a record of that. Special needs trusts, once they become irrevocable, which generally doesn't happen until the parents pass away. Tax returns must be filed on an annual basis because they have a separate tax ID number. Now, that being said, and this is a real common question, any money going into the trust is not taxable. The only thing that's taxable is any income that's going up, but any payments are a deduction. A properly managed special needs trust should never be having to pay income tax. The trustee has to serve as an advocate or hire an advocate. Somebody must be advocating for that beneficiary's benefits. Make sure they're adequate. Of course, housing, caregiving. The common question I have is there any personal liability upon the trustee? Well, as long as the trustee is not acting badly, stealing money for its own purpose, then there's no personal liability. Managing those benefits, again, a key aspect of a special needs trustee. Another question I get asked, is there any tax liability? There's no tax liability upon the trustee. They are entitled to compensation. So if compensation is being taken, you've got to report that, pay income tax, SSI, and all those various things the government takes out of your paycheck. So, funding a special needs trust. Frankly, what most people do is that have special needs trust is they're going to fund that special needs trust when they pass away. But there's other great ways to fund a special needs trust. Certainly life insurance. I'm a big advocate of life insurance. Term life insurance is good. Whole life is even better to fund special needs trust. I'm a big advocate of whole life insurance. There's some significant tax advantages. These days, a lot of people accumulate assets via their 401k or IRA, so forth. That's a great way to fund a special needs trust. And in fact, the IRS gives special treatment to 401ks or IRAs that go into a special needs trust. Inheritance gifts. Key point is whenever you're funding a trust, funding is the name when you're putting money into the trust, or you're planning to leave money, or you're naming the special needs trust as the beneficiary. The key thing is you've got to specifically identify the special needs trust. Now, this isn't very complicated. It's just every special needs trust has a name, the third party trust of John Doe dated May 1st, 2018, something like that. Very simple, but you've got to use that name. That's imperative if you're going to leave funds to a special needs trust. Usually those names are all over the special needs documents. There's other supporting documents like certificate of trust and so forth, where that name is all over the place. Oftentimes, attorneys will prepare trustee letters that can be sent out to potential people like the grandparents who want to leave money to their special needs grandson. Well, who needs a special needs trust? Well, obviously somebody has disabilities, right? That's pretty common. But also we do special needs trusts for those with drug, alcohol abuse. I didn't include this, but gambling or are unable to manage money. I get a lot of those. Mental illness, accidents. These are all situations where a special needs trust can be and should be utilized.
Jeff, I have a question.
Perfect.
Does that person who is the beneficiary of a special needs trust have to be someone who is also conserved?
No. A conservatorship is a completely separate activity. Often they are, but often they're not. So, for example, I do not have conservatorships over my son. They're both high functioning, compliant, easy to go along with, and so I don't need a conservatorship, but often others do. But again, they're completely separate. Any other questions? I'm going to kind of switch topics here and move on to benefits.
That was it for that topic. Thank you.
So what is the planning process for special needs trust? So typically when I'm talking to families, I'm gathering information on the family asset structure, the dynamics of the family, and most importantly, what benefits is the individual receiving. It's important that we're creating a plan that protects those benefits and creates a financial structure for the individual. Majority of my time is spent advising and protecting benefits. You can't do special needs planning without benefits. Are you getting the theme here? The benefits are important. Next slide here. So the public benefits can be defined in two different broad categories. I call it one category means tested public benefits or entitlement benefits. Means tested means that you qualify because you're either you're disabled and you have limited income, limited assets. Entitlement just means you've paid into the system and you're entitled to those benefits just because of a taxpayer or you paid into SSI and so forth. So I'm going to jump into SSI. Typically, I find that the vast majority of people with disabilities, the two programs they have receiving benefits is SSI and Medi-Cal. So we'll talk about SSI first. So next slide, please. SSI, I could spend a half hour talking about SSI. So which I can't do that or we're out of time. So I'm going to just kind of hit the highlights of it. SSI, Social Security Income. You have to qualify for it. It's a monthly benefit. People with limited income resources, blind, age 65 or older, qualifying disability. I'm not quite sure why age 65 is considered a magic term for it, but it's in the statute. I don't really think that if you're age 65, you're automatically disabled. Children with disabilities can only get SSI based on their parents' income. SSI is the most common, but also the most complicated benefit, and it's the easiest to get in trouble. Go on to the next slide here, please. So the federal benefit for SSI for 2024 is $943 a month. California adds another $219, which most states do not add additional. California is one of only a handful of states that supplements the federal SSI benefit with the state benefit. So currently it's just slightly under $1,200. Social Security does not make it easy to know whether you're receiving SSI or SSDI or just regular Social Security. So frequently I'll ask parents, what benefit are you receiving? And they don't know, which is expected. And so I'll ask them, well, how much are you receiving? And if they tell me 1,180, a little under 1,200, I know they're receiving SSI. And there's a lot of rules with SSI that are not associated with other Social Security programs. So there's two tests. One is they've got to be disabled. And so substantial gainful activity. I'll give you the exact wording here in a moment because it's important. The second test is you have to, I call it POUR. That's my term. So yeah, there's both within that, there's a resource. That's the term they use. I call it asset. How much stuff do you have? And income test. So those are limitations. So you have to meet both the tests, be disabled and be poor under their test to be able to qualify for SSI. Frequently, our clients that are turning 18 that are disabled usually meet the disabled test and almost always meet the poor. But generally, our 18-year-olds don't have assets and our disabled don't have income. One of the unique aspects of SSI is to pay all food and shelter. Any other outside payment for food and shelter reduce the SSI payment. Okay, so we go back up to the payment here where that's a shy under $1,200. I don't know any place in California that you can rent a place, pay all the utilities, buy food for $1,200. But that's what the rule is. Now, fortunately, there are some workarounds, which I'll get to here in a while. Next slide, please. So this is the official definition of a disability: inability to engage in substantial gainful activity due to any medically determined physical or mental impairment or combination expected to last 12 months or until death. So this is a special language in it. Some people that some people who turn 18 which have issues, especially if they have cognitive skills, sometimes have a hard time meeting this test. And if they do, I highly recommend hiring an advocate for this. Oftentimes it's not. My son that was cerebral palsy, I remember we went to the doctor's evaluation and he was in there for about 5 minutes and the doctor came out, and I don't think he's supposed to do this, but he nodded his head at me. It was instantly clear that my son was met the definition of a disability. But others have to work on that. Next slide, please. So there's two what we call money tests. One is an asset limit and one is an income. So the asset limit for a single person is $2,000. For a married couple is $3,000. So frequently when we have people who are interested in marrying, we tell them go ahead and get married under the eyes of the church, but maybe not under the eyes of the government. Why the government penalizes a married couple? I guess the theory that two can live cheaper than one, maybe so, but that's not very much money. These numbers were established, I believe, in the late 70s and have not been escalated since. They weren't indexed for inflation. And so right now, if that $2,000, if it had been indexed, would be about $12,000, $13,000, somewhere in there, that range. For a minor, they count the assets of the parents. I've had several instances where people will come in, they'll have their son or daughter who are now in their 20s. I'll ask them, they're not receiving SSI. And they say, well, we tried when he was 7, 8, and we was denied. And so we haven't tried again. And I'm going, So when they turn 18, and this is important when you're talking about benefits, you need benefits. When somebody turns 18, think of them as a household of one. The government paperwork is very confusing because they talk about how many people are living in the household and so forth. And I won't get into the details, but what you're going to do in order to get around the food and housing thing, is you're going to say that when your child turns 18, you are not going to provide any food and housing. Well, that's sort of counterintuitive, right? What parent would not provide food and housing for the disabled child? Well, what you're going to do is you're going to charge room and board out of that SSI check, and you put that down. And so you're going to charge room and board, and therefore that SSI check is in fact paying for all food and housing. So you're meeting the rule. This is not some trick or some under the table secret way. The SSI website actually states this is something that you can do in order to qualify for SSI. Nobody really believes you can survive anywhere, probably most of the United States, but certainly in California, on $1,200 a month. Let's move on to the next slide, please. This is, like
Jeff,
I said, I could.
I'm
yes.
sorry to interrupt you.
Sure.
I do have one question that has come up regarding the definition of a married couple for SSI benefits. And it seems that the Social Security auditors have become aware that some people are living like married people and are now using that as a means to audit whether or not people meet that income and household criteria, even if they are not legally married. Is that something that you can explain a little bit?
Well, I'm sure I have not heard that, but yes, if you're holding yourself out as husband and wife, the wife's taken on the husband's last name and so forth. Yeah, you're going to be they're going to be looking at that, but I have not, in my experience, I have not seen that. So that must be something new, or maybe they were really holding themselves out as husband and wife. But I really can't answer the question because I just have not seen it as a problem.
Okay, thank you.
Sorry. Let's go on next. On my last chart on SSI, it talks about income tests. And so if you'll move on to the next slide, please. There are 4 types of income tests: earned income, earned, unearned income, deemed income. I could talk about 15 minutes about the income rules on it. I'm going to skip over it. Just be aware that there is income, and if you have somebody who's on SSI who's working, you need to report that income. So people get in trouble by not reporting. So just really quickly, without going into the weeds and all the numbers and so forth, my son worked in my office. He's the king of shredding. So he works a couple hours a day, 3 days a week. And so what I did when he was on SSI is I reported it. I reported it. They go through this calculation and they would reduce his check. It was never very much, $50, $80. They reduce it. But what the people get in trouble is they don't report that. And then Social Security and IRS will match up those records. Trouble is it's like 4 or 5 years downstream. And so SSI will say, you didn't report this income that you had from 4 years ago. So we're assuming that same income occurred for all these years. And we're going to tack on interest and penalties and please send a check in the enclosed envelope for $45,000. I've had clients get that. Obviously, it makes them very upset. There's workarounds. We've never had to send any large checks. There's a way to work that issue. So don't be afraid if you do that. But the best way is if you are receiving income, their SSI is going to find out about it and just report it, and it makes life a little easier. I'm moving on from SSI to the next chart, please. I'm going to jump into SSDI. So SSDI is entitlement benefit. You're entitled to get SSDI or your children if you paid into it. So let's move on to the next slide, because this really is very important. It's just a super benefit for somebody who's paid into the system. And again, if we can move on to the next slide, that would be good at this point. if somebody is paid into the SSDI system, their disabled son or daughter can collect money when they start collecting Social Security. So the disability must occur prior to age 22. SSDI can be much higher depending on how much money was put into the system. All the SSI rules go away. All the rules about SSI has to pay for all food and housing, all the rules about reporting income, all that goes away. Unfortunately, it's not available to those who do not pay into the SSDI system. And there's some, especially government groups, so teachers, I believe, on PERS, I don't think pay into the SSDI system, but it's a great benefit. After 2 years, you automatically get Medicare. So you get Medicare and Medi-Cal. I'll use my son as an example. My son's now in his 30s. So at that time, many years ago, he was receiving about somewhere between $800 and $900 for SSI. And my wife decided to take an early retirement and went on Social Security. Because she had paid into the SSDI system all those years, my son was entitled to SSDI benefits. So he went from SSI to SSDI. The amount he received doubled. So it went from $800 to roughly $1,500. And I didn't have to start sending any more letters in to Social Security about income. Really a nice benefit. And generally, sometimes SSI will do, Social Security will do that automatically, but generally you have to ask for it. So if you're thinking about maybe starting Social Security early or not, that may be a factor in your decision. Certainly in the end, it was more beneficial for us, for my wife to take the reduced Social Security, and then my son get a much higher benefit from Social Security. And then having Medicare in addition to Medi-Cal just made it all that much more better. So it's something to look out for. Let's move on to the next slide, please. And we're going to talk about Medi-Cal and then IHSS also. Medi-Cal is extremely important. I think most people I know are on Medi-Cal, and Medi-Cal is seems like it's very easy to get on. So let's move on to the next slide. It's a great program, broad coverage. It's a strange program. So Medi-Cal is California's version of Medicaid. It's the only federal program I know where it's a federal program. The states have the ability to set the rules by asking what they call waivers, and then the local counties actually administer the program. So you got 3 different government agencies working this. Medi-Cal used to be horrible. 10 years ago, it was horrible. But most counties in California now have gone to managed care programs. So you'll have an organization like Molina or IHP or others in the various counties that are providing care. Since that has occurred, the level of care has been dramatically improved. I know for me, I was very concerned when my wife retired. My son lost his the Toyota insurance that we had through my wife, and I was very concerned that he'd have to go onto Medi-Cal. Well, it was not. This is before he was on Medicare also. I was very concerned. Went into a managed care program. He was going to the same doctor as me. It was just seamless. In fact, I had to pay a $30 copay, and my son was free. So the current program is great. Interesting change this year. So up until a couple of years ago, the Medi-Cal had the same asset limits that SSI did. 2 years ago, it went to you could have up to $140,000 under a waiver program from the federal government. This year in California, and only California, you can have unlimited assets and still qualify for Medi-Cal. So in essence, Bill Gates could be on Medi-Cal based on his assets. However, there's still an income limit, and the income limits are pretty severe. They're pretty low. The thing is, there's about 90 different programs. It's a very confusing area. I actually do work with an expert on Medi-Cal when I'm trying to get people qualified for Medi-Cal, because there's something like 90 different waiver programs that people can get on. So they may have in one program too much income in one program and another. On SSI, you immediately qualify for Medi-Cal. So if you qualify for Medi-Cal, you automatically qualify for, if you're on SSI, you automatically qualify for Medi-Cal. However, when you go off SSI, you lose the SSI-based Medi-Cal. So when my son switched from SSI to SSDI, I got this letter from Medi-Cal saying, your son has been removed from Medi-Cal because he no longer qualifies. I'm freaking out. I'm going, oh my goodness, my son doesn't have any medical insurance. Well, so we went into, the next day I got a letter from Medi-Cal, literally the next day, that said, well, he's now on the share of cost program. So we've done an analysis based on his income and so forth, and it's now $20 a month for his to remain on Medi-Cal. Happy to send him $20 a month for to be on Medi-Cal. Next chart. IHSS. Just about every one of my clients are on IHSS. It's really a great program. Basically, it serves children and adults too, seniors, that are unable to perform activities of daily living and cannot remain safely in the homes without help. It's a very popular program, very bureaucratic, but it pays caregivers, usually parents, to form services and all types of services, whether it's domestic, meal prep, transportation. The thing, it's got to be hands-on work. So you've got to be actually doing those. You can't be thinking or planning. It's got to be actual hands-on work. And then, so when you're applying for IHSS, you need to think about the entire day, how much you spend doing hands-on work. And that's how you maximize the number of hours that are awarded. Unfortunately, it is very bureaucratic. My wife went through the process of getting IHS for my son. Many hours, the local county office, many hours gathering documents and so forth. Can be frustrating, but in the end, once it's awarded, it's just a great benefit. Next program. Next. Go ahead. We have a question?
Yes. So, Jeff, I'm wondering if you have seen this issue. As an advocate, I have experienced this specifically regarding that year 17 to age 18 transition for clients who are regional center clients who have Medi-Cal coverage via the deeming waiver through regional center. And then their Medi-Cal coverage gets abruptly interrupted because sometimes they're not being informed that they need to transfer or talk to their county office about extending those benefits past age 18 while they're transitioning to SSI and then maintaining eligibility that way. And then they have this cascade of losing Medi-Cal, IHSS, and then it is a huge mess where there's a gap in services. So I'm wondering if that's something you have also encountered and if you have any advice on how to get ahead of that.
Well, I have not. So I have not seen that from my own perspective or clients. But as I said, the whole process is very the Medi-Cal process is very bureaucratic. You know, so I think the key is staying ahead of it, and applying for SSI in advance if you can. Although that sometimes is a problematic, but stay on top of dealing with the Medi-Cal. You do bring up. I'm glad you asked that question because there's an important thing I want to share with you all in that. If the government ever tries to eliminate a benefit under a Supreme Court ruling, which I forgot the name, but it probably doesn't matter, the government must notify you and must give you an time limit to appeal that. it's extremely important to open the mail, and the mail from Medi-Cal can be confusing. It's confusing to me, and I'm an attorney, and I see this stuff all the time. It's still confusing what they're trying to say. But the point is, if they're threatening to cut off benefits, it's imperative to immediately file some sort of appeal. Once an appeal is filed under the Supreme Court ruling, they must continue benefits until it's until the issue is resolved. If you blow the time limit, and it can be fairly short, 10 days, 30 days, 20 days, 15 days, if you blow the time limit, they can shut off benefits. So my message to you, when you receive something from Medi-Cal, open the mail. If they're threatening to cut off benefits, immediately file a repeal, and they're required to maintain those benefits until it's resolved. I mean, that's one way to stay ahead of it, but that's normally not. You hope that doesn't come to that you can work it before you get those letters. But if you do get that letter, I can't emphasize how important that is. Any other questions? I'm going to quickly run through the others. Will go pretty quickly. IHSS, it is a Medi-Cal funded program, so you have to have Medi-Cal before you can receive IHSS. So oftentimes we won't see that until somebody reaches age 18. The theory behind that is, as a parent, you're legally responsible for caring your child till they reach 18. At age 18, there isn't that legal requirement. That's why at age 18, it's a household of one. Generally the maximum hours is 198, and there's a protective service category of 298, I believe, if they require 24-hour protection. The challenge always with IHS is trying to maximize the hours. Let's move on to the next chart. I think we'll food stamps. Next chart, I'm going to just talk very briefly on this one. So I think everybody has seen the signs in front of the stores. We accept EBT and so forth. That's all food stamps. The thing I want to stress is, up until a couple of years ago, if you are receiving SSI, you were not permitted to receive food stamps. They keep on changing the name. I think right now it's called CalFresh. It used to be called SNAP, and then it's EBT. Anyways, and I've had parents come in and say and not know about that. They said they applied and couldn't get it because their son years ago was they applied years ago. So the rule is now, if you're receiving SSI, you can also receive CalFresh food stamps. That's really my important message. And there's another bureaucracy thing you got to go through, but it's worth it. Next slide. Regional centers. I think I'm going to skip over the regional center section. I think everybody is probably on this phone call is familiar with regional center. It's a fabulous program. It's unique to the state. Next slide, please. It's unique to California. No other state has something like regional center. I guess my one message is, every once in a while I'll have a parent come in and say, well, I don't like the services that regional center is providing, so I've stopped using regional center. No. Regional center is it's a lifelong benefit. So once you get qualified for regional center, you want to stay on that regional center lifelong benefit. It's going to be something that's going to be provided to your son or daughter long after you're gone. So, and it's a wonderful program. A little bureaucratic, but and people complain about it, but boy, it's so much better than any other state in the country. Let's see. Next slide. Next. I kind of talked about this already. Quickly, utilities. I think most people know this, but if you don't, both the gas company, the electric company, and the internet companies, I believe, all have what they call care programs that will provide a 20% discount on your household bill. And generally, all you have to do is show that one person is receiving a Medi-Cal or SSI. You'll immediately qualify. Every year you have to usually requalify, but that's another great benefit. And some of our hotter areas, having that 20% discount can be a big deal on reducing that electric bill. Education, I'm not going to. That's a whole topic that we have an expert here, an advocate on all the rules about special education. I wish that I had hired an advisor, an advocate back when my kids were in school years ago. And so if you're having issues, hire an advocate. They can make life so much more. The school districts have all the knowledge. They're the decision maker and all the knowledge. You need somebody like an advocate that can have all the knowledge also and advocate on your behalf. I know we've been going for a little over an hour. I was going to talk about ABLE accounts, but I'm not sure if we want to continue or we want to take any more questions, or how would you like to proceed at this point?
You're doing good on time, so go ahead and talk about the ABLE accounts.
Okay, great. So ABLE account, boy, what a great tool, especially CalABLE. CalABLE. Let me emphasize that. So next chart, please. So what is an ABLE account? ABLE account is something that it's a state-run account that was authorized by the IRS. It's a 529 account if you're into IRS codes. And what it is, a student savings account and so forth fall under the same code number. So what it is, it's you can set up an account, you can put money into this account, and it grows tax-free. Huge benefit. It can be either first party or third party. So you have first party money, third party money. You put after-tax money into it, and it grows tax-free, which is a huge advantage about growth. When IRS came out, they required a Medi-Cal payback. And so if the person passed away and there was funds in it, Medi-Cal or Medicaid would come in and swoop out the money. It really killed it because of that payback provision, it really killed it as a savings device. Nobody wanted to put all their hard-earned money into it, grow real large, and then the Medicaid comes in, takes the money out, they pass away. There was an issue between California and the IRS. California said they didn't want to do it. IRS said you had to do it. Kind of went back and forth. Early last year, IRS came out with a ruling that said, if you have a CalABLE account, we are not going to require any sort of Medi-Cal payback. Changed everything. So suddenly it became a good savings device. I had my son early on when they first came out in Ohio that this was way ahead of California. Last year I moved it over to CalABLE because it provides that no payback provision. Let's move on to the next chart, please. You can contribute up to $18,000, and then if the person happens to be working, the disabled person happens to be working also, those earnings can go in there also. It's the beneficiary's own account, but the parent or guardian, conservator, power of attorney can also set that up. I think it's called the authorized representative. They have the term is slightly different than SSI, but it means the same thing. This is all online, so you don't go down to your local Bank of America or Chase or whatever set up. It's online. You do it online, and so you open up an account. Literally took me when I opened up the CalABLE account last year to about 15 minutes. It's for a government website. It's actually a really good website. They've got lots of tutorials on there. And it's something that it's easy to set up, easy to put money into it, a great way to save it. It can be used for housing. So one of the things that we talked about earlier with SSI is that if you have outside money coming in, it'll reduce the amount of SSI benefit. But there's an exception for ABLE accounts, so you can legally launder money through an ABLE account to pay for housing, and kind of contrary to common sense, but that's perfectly allowed. So people are doing that now if they want, especially let's say a parent has purchased I'd say a condominium for their special needs individual. And typically they would, there was no, in that situation, you can't really do the room and board. And so though any money spent for that housing would be a 1/3 reduction. Well, now you can take that money, put it into an ABLE account, and then through the ABLE account, pay for the housing, and you don't have to take that 1/3 reduction. SSI will be suspended, not terminated, but suspended if the account reaches 100,000. Now it takes a long time to reach $100,000, but you certainly don't want to let the account go above the $100,000 if it would not make economic sense to lose the SSI to let it allow to go over 100K. A great way to save it. Now, that's one side of it, the saving portion. The other side of it is the spending portion. And so they have a TrueLink card that allows your beneficiary to buy things with this TrueLink card. It looks exactly like a credit card or a debit card. But the beauty of this TrueLink card is, first of all, normally you can't give cash under the SSI rules to your son or daughter because that's called a gift and it's a reduction. But under the rules with a TrueLink card, you can give them a TrueLink card. They can go out and spend money on this card, and it doesn't impact SSI. More importantly, is that you can control how much money is spent. So, for example, my son, we had a debit account for him under the bank, just a regular bank, and while he's barely high functioning, he really can't count money and so forth. So he really is subject to financial exploitation, and he has been, and created some big problems because people were taking money out of his account. He was giving away information. We now have this TrueLink card that is really his only way to spend money. I have the ability to limit how much money can be spent, where it can be spent on, and also I'll say, okay, there's a maximum amount per day is $50, and only can be spent at restaurants or fast food places, that type of thing. And then every time he spends money, I get a text how much money is spent. So it's a nice balance. It allows your disabled individual to have the freedom to spend money, the freedom to make decisions on what they want to do, but the protection so they don't get abused. I think it's a great tool. It's a nice combination with having a special needs trust. So, there's some limitations with the ABLE account. Can't go above 100,000. You don't have the controls and the planning and so forth you do, but it's a nice thing to have both tools available. And so I advise people who are thinking about funding the special needs trust or thinking about funding the ABLE account, I say fund that ABLE account first because you get that tax advantage spending. Next slide, please. I think I covered everything I want. Oh, yeah, okay, the eligibility. So you have to have, currently the current rule is you had to have a disability that occurred prior to age 26. The age 26 was completely a random number. Congress, when they came up with this, just figured out how much money they were going to lose and came up with 26. This has been very disappointing as an advisor because I'll have people coming in that where an ABLE account would be perfect, especially for those mental illness and so forth. The onset didn't come on until after age 26. The good news is in 2026, the age has increased to age 46. It's fairly easy to qualify. If you're on SSI or SSDI, you automatically qualify. Then there's a very, very lengthy list. They call it List of Compassionate Allowance Conditions. That's their term. And so if you meet one of these lists, and it's a huge, huge list, you just self-certify. You have this condition, and you qualify for an ABLE account. It is subject to the IRS, so the spending has to be by the sole benefit rule. Qualification and spending is subject to IRS audit. There have been 0 IRS audits so far. You can imagine the newspaper headlines if the IRS started focusing on our disability family members and not not more wealthy people. So I do not expect audits. However, I think it's subject to it, and so you just need to follow the rules.
Jeff,
Yes.
this is slightly off topic, but while you were discussing using the card that's associated with the ABLE account and the use of counting cash and money, it made me think of some of the things that frequently come up in IEP meetings that I attend as an advocate. So I just wanted to mention that that might be a really good transition goal for any of the parents who are still attending IEP meetings for school-aged or high school children, to talk about developing IEP goals to use electronic debit cards at community-based outings, because that would be a really good skill to prepare them for use of their ABLE account when they leave the IEP program.
Absolutely. I hadn't thought about that. I think it's a great idea.
That's why they pay me the big bucks, Jeff.
Just one last final thing. Next chart, please.
Jeff, you do have another question regarding ABLE accounts.
Sure.
This question is asking if there is a way to convert a previous 529 education account before the disability was known into an ABLE account, or to move those funds from the 529 into the ABLE account.
Yeah, I'm pretty sure there is. I'm glad you asked that question. I remember reading it a short while ago that I think the IRS does allow that. So I haven't tried to do that myself or advise anybody that. I don't know the mechanics of it, but I do know there's been a lot of discussion about the ability to change from a former student savings account to an ABLE account. So I think you can do it. I'm going to look into the mechanics of that. That's something for me to do to check into that more, but I'm pretty sure you can.
And I would also assume that wherever that 529 is being maintained, that they would have financial advisors who are registered that could probably answer that question as well.
Correct. Now, the financial advisors are probably not going to be motivated because the money, an ABLE account can only be within the state-run agency, so they're going to lose that. They're going to lose those funds. But still, yeah, I think that's I think there's a real need for people who have done that to transfer those funds. Next and last chart. So we hit all the benefits. One last thing I wanted to cover. Next chart, please. So, it's very important that everyone have an advanced healthcare directive or a financial power of attorney. Now, if one doesn't have legal capacity to do that, then we're talking conservatorships. So at some point at age 18, you need to do one of them either. You need to go get a conservatorship, a limited conservatorship, or you need to get an advanced healthcare directive and a financial power of attorney. Really important. And the whole limited conservatorship process, that's a whole different presentation that takes about an hour to go through. But I did want to emphasize that you got to do something at age 18 in that matter.
You do have another question. It says that their child is a regional center client and is working. And on the topic of CalAble and independence, what are your thoughts of their child using an FMS to manage their finances?
FMS meaning?
Financial management service. It sounds like maybe there's some, I'm wondering if there's some maybe thoughts about the self-determination program model, but maybe on a larger scale Maybe this person can clarify if they're, Selena, can you clarify if you're asking about self-determination and the FMS, or are you talking about having a financial company or a financial planner manage the finances? Can you chat and clarify your question, please? You can also unmute your microphone or turn on your screen if you sign and clarify.
I kind of think I know where she's going on this. The self-determination topic is part of the regional center thing. It's fairly new. Great program. I've got a couple of clients that have gone through it. It's a great way to, if you have the effort to go through the whole process. It's a new program that I think can be very beneficial. And I think part of that includes having a separate organization pay for the expenses. So that may be what she's referring to.
Yes, she did clarify that, and I can kind of take that question too. We just had a presentation on this exact subject that will be uploaded to the NorCal website soon on the exact topic of the self-determination program, using an independent facilitator and how to select the FMS. So if you would like more information about that, you're certainly welcome to follow up with us and make sure that you have access to that recording. But if you have any questions specific to financial management outside of the self-determination program, please put that in the chat box so that Jeff can answer that for you. One question that was written down as well was how and where to store important documents. It's nice to have all of these things available and prepared, but what is your recommendation for making sure that should something happen to the primary caregiver, all of these documents and the wishes that are contained therein are going to be found by the appropriate people?
So when it comes to estate plans and special needs plans, and so we always encourage people to put documents into these two folders, and if they want, I'll go ahead and upload it for them into the cloud. And so things like memorandums of intent and so forth that include a lot of this information, store it we recommend storing in your estate planning documents. I think that's what people will be able to find it, or you can refer to something else. The one point I want to get across is you should not put these documents inside a safe or a safe deposit box. You need to keep them out where people can find them. This is a real common problem. We and most attorneys don't have any sensitive financial information in these books. So there's no social security numbers, there's no routing numbers or account numbers or anything like that people could use to create some financial havoc for you. So keep them out where people can find it easily if something happens. We've had several instances where people have unfortunately passed away suddenly, and they knew that they had created an estate plan, but they couldn't find it. And we had one incident where we had to go through a full-blown probate because they could not find it. They thought it was in a bank account and so forth. And so keep it available.
Okay, and then one other question was regarding SSI overpayments, and that being a fairly common issue. Would you recommend foregoing access to SSI benefits entirely if you can appropriately fund a trust?
I would never forego SSI benefits. I mean, it just goes on and on and on. So I would never forego SSI benefits. And hopefully there is not an overpayment. But if there is a whole overpayment, the most SSI can do is reduce the SSI, the future SSI payments by 15% to recover those lost payments. So let's say it's a huge amount. Let's say it's a $50,000 overpayment. You know, nobody, you do not have to write a check for $50,000. What they'll do is they'll reduce the future SSI benefits by only 15%. So no, I would never forego the SSI benefit, and I always make sure you're getting the maximum. If you're getting, one of the things I'll ask about how much the SSI, I'll ask about, you know, what's it get, and what are you getting? And if they tell me, well, $800 or $750 or something, I know they're taking the 1/3 reduction. So I'll say you need to immediately, this is really a common mistake. People fill out that initial form, say they're going to provide housing and food, and they immediately take a 1/3 reduction in the amount. So if they're not receiving the full amount, you can go back to SSI, it's entirely proper. It's even documented in their website. Go back and say you've changed how you're doing the financing. You're now charging room and board, and they're assisting. They're not receiving free food and housing, and they'll raise the amount to the full amount. So you should maximize that. You know, you take that SSI benefit and stretch it out over a lifetime. It becomes just a huge amount of money. So no, don't ever forego it.
Well, that was a lot of information, very valuable information. On the topic of where to put important documents, what I did is I bought a binder that is bright red, and I put it in a specific place in my house, and I told a short list of people that I trust where that information is. And, you know, because I'm the primary caregiver, I left notes that I think would be useful specifically for my husband, because God forbid something happened to me, I know that he would be very overwhelmed jumping into the world that I live in with IEP meetings and IPP meetings and IHSS and everything else that I probably make look too easy on a given day, which is not easy. But I made notes, but they would also include things like, this is what is helpful specific to my child's needs. So, you know, if I go to this emergency room, I would ask for a room ahead of time. I call and let them know, hey, we need an ASL interpreter, we're coming in. So it's more than just trust documents and bank account information. It's also things that if I'm completely incapacitated, I want to ensure that there is the least amount of interruption to my child's day-to-day as possible. So, and then what I do is I update that usually around New Year's every year. And I just update it on my computer and print it out. And so I have a digital copy and a hard copy. So I think that, you know, as daunting as that might sound, and I'm admittedly a little bit type A personality and a little over-organized, that is, I think, something that a lot of us become when we live this life of parents of children with disabilities. So that's my little parenting life hack, is to have a bright red binder that has not just all the legal and banking and, you know, boring information, so to speak, but the things that you really would want someone to know that would minimize the interruption to your child's life should something happen to you unexpectedly or when the expected does happen and you eventually are no longer their primary caregiver. So anyway, on that note, we are right at our time where we're scheduled to conclude. I want to thank our interpreters for facilitating communication access to today's presentation. I want to, of course, thank Jeff for his time and his expertise. It was a wonderful amount of information that we, of course, as parents know is something we don't necessarily want to think about, but it's really important that we do. And here at NorCal, it's a team effort to coordinate these support groups. So thank you to the entire team that made it happen. It was a success, no doubt. We will be sharing a survey, so if you wouldn't mind, please participating and letting us know feedback, how we can improve, what information you would like to see us present in the future. And on April 25th, we're going to schedule a casual conversation, same time from 10 to 11 in the morning. And it will just be a chat with myself and with Diane Olafson from NorCal, where we can have a open discussion on any of your concerns you might have as a parent of a deaf plus child or adult. All right. Well, we hope everyone has a great day. Thank you for joining us again. And we hope to see you at our next event.
Thank you.